Good afternoon and welcome to today's Knowledge Bank. Today's webinar is going to be hosted by Matt Lewis from Commonhold and Leasehold experts. If you have any questions throughout the webinar, please submit them in the Q&A box at the bottom of your screen, and we will try to get through them at the end of the session. The webinar is also being recorded today and will be available to watch back on the News on the Block YouTube channel. If you would like a copy of the slides, I will also be able to send them via email. That is all from me. I am now going to hand you straight over to Matt.
Thanks so much, Vicky, and good afternoon, everybody. First things first, thanks, Vicky, and all at News on the Block for the opportunity to speak on topic. I really appreciate it. Second, I must say, being a person who always holds his glass half full and hoping to be positive in general, everybody should look to identify the good in proposed reform and see this as an opportunity for really good, positive change in our industry. By way of an introduction, for those that don't know me, I'm a solicitor, member of the IRPM, honorary consultant of the FPRA, and co-founder of a training company, Leasehold Management Professionals, LMP, on the South Coast. And in my private life, I have a young family and live on the South Coast, close to Bournemouth and Poole. And I've worked in this industry for a substantial amount of time. And during this time, there has always existed this conversation regarding ongoing reform. And that leads me on nicely to the topic of the day. In the last few weeks, we've been littered with a pepper pot of announcements, and it's frankly shaken up our industry entirely, in my view. Today's session is going to be my attempt to bring it all together, and in particularly to look at yesterday's events and what we should be thinking about now. In context, a few things to start with. This is a general talk, as those listening are leaseholders, landlords, directors of residence companies, managing agents, other solicitors, barristers, accountants, surveyors, and other professionals working in the block management and leasehold reform sector. My hope is the nature of this talk, it will guide everybody in a general manner regarding the announcements and talk through next steps in a helpful and constructive way. In this respect, also the King's speech was just yesterday, and so I'll only be able to comment from a very relatively high level as to what's been said and the next steps associated. Finally, on this slide, as reform is well underway, we plan to bring you more of these update sessions and more regularly as the proposed bill passes through Parliament, and particular emphasis in those talks will be on risks in that moment. And please do sign up to those or sign up to updates from News on the Block on future sessions. So a quick bit of housekeeping before we get going. A couple of things. I'm really into gifts and somewhat known for it with my role at LMP, but I've reined it in today, I must say. And I've done that because the topic is particularly important and serious in nature. And I note that a number of individuals and stakeholders in the industry are particularly impacted by proposed reform. Entirely irrelevant for these purposes of today, but I'm a Leeds fan too, and if anybody wants to talk about football at any point, please do let me know. And as for today, some housekeeping. So we're just looking at information today and not advising. That's significant. I'll come on to that again in a moment. I'm a lawyer and nothing else, and so I'll comment from my perspective, but I'll stay in my lane very much so, but I'll comment on other professionals that would be relevant to your ongoing review of this position. We'll be dealing with some Q&A at the end, but I'm conscious that there are a significant number of individuals on the call, and I'm conscious that I've been given an hour and been told to be relatively punchy, and so we may not have time for all questions raised, but I'll do my best to pick off some of those if we've got some time. In Q&A, caution with any confidential matters, and consider before oversharing. And I'd really appreciate feedback, and please feel free to raise that with either Vicky or directly to myself. Goes without saying, but whilst you read on screen, the key takeaways here are hoping to inform today. As I say, we're not advising. Advice requires specific details, particular circumstances and application to those things with reference to the law, and notably not potential change in the law. What you'll see from this talk is that the law is proposed to be changing and fundamentally changing. And what that looks like at the moment is frankly unknown. We do not accept any responsibility, and neither do News on the Block. We've done all that we can to ensure accuracy, but please do not rely on content, and please take legal and other professional advice before you take any practical steps as to your personal circumstances. So, all of that housekeeping aside, part one, the story so far. So it all started way back when in 2011, some 12 years ago. This is not intended to be an entire list at all, and I'm not going to take you through each bullet point. Reviewing all of these in detail would take me all afternoon in itself, and we wouldn't get anywhere near the King's Speech. This slide is simply to identify how long this journey has taken, when it started, and in a very rough and ready manner, what's happened since. Many of us have really felt it through the uncertainty and not knowing what to advise our clients throughout this entire time. So further in part one, the story so far. The legislation already in force that's relevant to this particular conversation. And this is where we are so far with a long winding road of reform. Again, not going into detail on these, as I expect most of you are well versed already on some or most of these, particularly in the property management sector. And also, it's important to note with some of these that we are still waiting on various pieces to develop. So primary, for example, building safety, secondary legislation. And further, for example, there was a consultation in the summer on whether or not the 2020 planning regulation should continue. This, of course, has huge implications for valuations on collective enfranchisements in particular circumstances. And we have no word yet on if this will continue or cease. Also note building safety, it's very much unknown with parts of this in limbo. And so more on this later, as this was touched on within the King's Speech. All that said, on the story so far, I'm going to talk very briefly about the Levelling Up and Regeneration Act on the next slide. This is one primarily for the lease extension valuers and lawyers who have been affected by the building safety lease extension trap. I appreciate this has also hit the death of some managing agents. I've not as of yet heard of any leaseholders adversely impacted, which is great, and I sincerely hope that none have. Particularly unfortunate, but the original version of the Building Safety Act left a loophole whereby certain leaseholders inadvertently lost their protections if they completed a lease extension or other similar transaction. Clearly, this had very serious implications, and in brief, the loss of those rights could mean that those affected ended up paying significantly more towards the cost of historic remediation than did before a lease extension or similar transaction. On the 26th of October 2023, the then Levelling Up bill secured royal assent. Within the final version of the bill, there was provision that changed the Building Safety Act definition of a qualifying lease to remedy this issue. Due to this amendment, which applies retrospectively, completing a lease extension will not result in leaseholders losing historic remediation protections, and this represents fantastic news for leaseholders impacted or considering any such transactions in relevant buildings. This is huge relief also for lawyers and valuers alike. Valuers no longer need to consider any adverse valuation calculation, and lawyers no longer need to negotiate additional clauses into lease wording and trying to save those protections. This is likely to be somewhat gibberish to some of those listening, but this will make sense to the enfranchisement lawyers and valuers listening, and any leaseholders that have had to concern themselves with this additional consideration as part of their claim. So that's all that's in play. What about those currently in progress before we look at the King's Speech? The quick answer to that is that there's not much going on insofar as current legislation passing through. For those that have heard me talk in recent times on this topic, the point of reform, there are a few things, however, to mention. The first two mentioned on the slide are private members' bills, and these are not government bills, but these are brought by individual members following a ballot. It's worth noting generally these don't ever make it to legislation or take longer to do so, and some of these have been impacted by the wider conversation regarding reform. In brief, the first considers insurance issues, which has somewhat been overtaken by the events of the work of government and the FCA, and more on that to come shortly. The second looks at the treatment of fixed service charges, which are generally quite rare, and so I won't go into that in too much detail on this talk, conscious we're here to talk about the King's Speech. The last is worth noting, however. Unfortunate that it's section 21, but section 21 of the Renters Reform Bill seeks to address the Housing Act trap. And this is in cases where ground rents exceed £250 outside of London or £1,000 inside London and other circumstances apply. The lease by definition can assume assured tenancy status. An assured tenancy can readily be terminated under the Housing Act legislation designed for short tenancies with more ease than the provisions relating to long leasehold forfeiture provisions. Leases where ground rents exceed this level may make mortgage lenders, and has been shown to make mortgage lenders, uneasy, and so selling or remortgaging can be particularly problematic in circumstances where the rent exceeds these thresholds. Most lenders require either indemnity insurance, a declaration from a landlord that they won't enforce Housing Act rights by way of a deed of variation, or a deed of variation to remove ground rents before they will lend. And some landlords refuse to enter such transactions voluntarily, and so lease extensions become necessary. This has caused real issues for conveyancers, landlords, and managing agents, with leaseholders often having to pay hefty fees to deal with this issue. Section 21 of the Renters Reform Bill is a simple piece of drafting that purports to address this by confirming that long leases don't fall into the scope of the Housing Act provisions. Now, this may seem like good news, but as some of you may have seen in the press in the last few weeks, the government seems to be stalling somewhat in terms of progressing the Renters Reform Bill. And it would be a real shame, in my view, if this does not progress to the final stages, as Section 21 of that bill, dealing with the Housing Act trap, is much needed for those leaseholders impacted and their conveyancers and mortgage lenders. So before we move on, and the final part of part one is the story so far and not just the legislation. So what about other things? It's important to stop and remember that it isn't just legislation that changes our landscape. On the slide, you'll see some examples of the other work which is or has been going through other agencies. The Competition and Markets Authority, or the CMA, initially investigated ground rents and leasehold abuses when buying houses, which eventually led to the Leasehold Reform Ground Rents Act of 2022, abolishing rents moving forward, except in certain circumstances, and the government's commitment to ban the sale of leasehold houses, amongst other things. The FCA has been looking into insurance commissions and recently issued their final findings on the 29th of September in 2023, which, coupled with the government reforms, will lead to a significant change in the way in which buildings insurance products are dealt with, affecting landlords and managing agents alike. More on this later. The building safety regulator, which is already partially live, will have significant impact on long-term management of buildings over 18 meters or 7 stories tall, My colleague recently attended the ARMA conference, at which concerns were very, very much noted by many managing agents over building safety case requirements due to come in force soon. Others on the slide you'll see are somewhat older, but fundamental to highlighting the various issues that currently exist in the system. So before we take a look at the King's Speech, I think it's important to recap on what we've spoken about. This slide sets out the happenings which have hit our industry in a very short space of time and some of the next steps. An awful lot for everyone to get their heads around. It affects everyone, as I say, landlords, leaseholders, management companies, managing agents, RMCs, RTM companies, and then all of the advisors. And so the lawyers, the valuers, the surveyors, the accountants, the estate agents, the conveyancers, and so on. We really shouldn't underestimate the impact the last few weeks have had on the industry and the next steps we'll have on the industry. And on that very heavy note, the King's Speech. And first, before I delve into it, I think it's important to note some of the reactions yesterday. And so some commented watching live that part of the King's Speech dealing with these matters was particularly short and they were somewhat underwhelmed. And further, some were further underwhelmed by the detail in the briefing paper that followed a few minutes later. And my personal view on all of that was that truly it was to be expected in that manner. And as we'll see later, all of the detail will come when we get draft legislation, a bill in time. For now, what featured in the King's Speech is separated into three parts above. And so the first part looks at enfranchisement, and second looks at consumer protections, and finally, the last part looks at enhancing rights. A bit of detail on this slide, but just pausing here, looking at enfranchisement, you'll see that I've separated on the preparation of the slides a chart explaining the application of each line item. Taking each of these in turn, first it said that the law will be changed. A new law will be brought forward to make it cheaper and easier for leaseholders of houses and flats to buy their freehold or extend their lease. And for those of us that have been working in this space for some time, you'll see that this is very much the theme of language which has been used for some time, following the Law Commission's work on the topic, the extensive work of the Law Commission on the topic. The second is that the entitlement to extend term will be to an additional 990 years on top of the existing term, and not an additional 90 years in accordance with the existing regime for flats, for example. The 2-year ownership rule will be removed such that any leaseholder can exercise these rights irrespective of how long they've owned their interest. It's proposed that the non-residential limit currently featuring in enfranchisement and right to manage regimes being increased to 50%. This will enable leaseholders that are in such developments to exercise those rights where they currently do not qualify. But much of this was discussed in well-known territory as possible features of reform prior to the King's Speech. Next, consumer rights. So in this category, we've seen a number of points made, and some of these have come as a bit of a surprise. First, there's a proposal to make conveyancing the process of buying and selling leasehold properties quicker and easier. And within this, there's mention of a proposal to introduce a time frame for applying to inquiries on sale, along with a capping of costs associated with replying. And this is the well-trodden path of LPE1 inquiries. In my view, these proposed reforms need to be approached particularly carefully. And this is to avoid any adverse consequences, such as limited information being given or no follow-up inquiries not being responded to. And in particular, what I have in mind here is that, in my experience, there are too many circumstances where individuals didn't fully appreciate what they purchased. And I think it's vitally important that all of the information is made available to a leaseholder prior to purchase. I think this needs to be looked at very carefully on point one. On transparency for service charge costs, it's proposed that there be a comparable format for this information, perhaps a minimum standard of information for service charge accounts. And so one can look at perhaps one development and compare it to another development and see at least a minimum standard of information and that transparency. On insurance commissions, as discussed throughout, these will be replaced by administration charges, which are capable of being challenged, are transparent, and within the reasonableness regime that currently exists for variable service charge costs. Redress schemes that currently exist will be extended to landlords not instructing managing agents, addressing this perceived gap in the current regime. And then next, there's a point on litigation costs and the presumption being changed. And so this is to look at a situation where a landlord places their litigation costs within either the service charge of a development or directly charges an individual leaseholder as an administration charge their litigation costs. There's reference in this bullet point within the briefing paper of the King's Speech or following the King's Speech where a leaseholder challenges their landlord. One point here, which will be important to see, is how this impacts on a very, very common scenario where costs are recovered as part of breach of lease proceedings, such as a failure to pay service charges. And so it will be important to see the detail there as to who pays costs in those circumstances or what the new regime looks like. Finally, on this slide, there's a proposal to introduce rights of transparency and rights to challenge for freehold house owners, similarly to those that exist for variable service charge costs in a leasehold arrangement, addressing that perceived or that gap in the existing framework. And then finally, on the content of the King's Speech briefing note, rights. So first, and perhaps most notably, there is reference to a ground rent consultation. It's described as a proposal subject to consultation to cap ground rents, existing ground rents. The reference is to the following. So there being no service or benefit in return for the ground rent, currently no requirement for ground rents to be reasonable, and where they cause issues when people want to sell their properties. Second, there's a proposal to enhance Building Safety Act provisions such that it works as intended, are the words which are used in the bullet points. We'll have to see further detail as to what's proposed here so that we can properly assess this point and what's being proposed. And then finally, there's a proposal to ban the sale of leasehold houses. And notably, this does not include flats in the King's Speech. So what's not in? I think that this is important to look at. So in the King's Speech, we didn't see any mention of the regulation of managing agents. And this has been an ongoing conversation in the leasehold reform landscape and the block management landscape for some time, following the work of Lord Best, commonly described as Roper, and bringing in Roper. Generally speaking, this is welcomed by the industry as a whole, the block management industry as a whole, as far as I can see, subject to further detail, and this didn't feature at all in yesterday's speech. Also notably Commonhold, and this is very much linked to the last point on my previous slide. And so the last point on the previous slide is the banning of the sale of leasehold houses. It's thought that the banning of leasehold flats going forward would require obviously an alternative product. And so the reinvigoration of Commonhold as described by the Law Commission's work is something that could have featured but did not feature in the King's speech yesterday. Also, the Law Commission reported extensively on a full set of enfranchisement recommendations in extremely comprehensive reporting, and some of those didn't feature, some of those did feature, and then the vast majority of right to manage recommendations within the Law Commission's work also didn't feature, except for increasing the non-residential exclusion limit from 25% to 50%. So moving on to part 3, and I think this is perhaps the most important element of the talk today, looking at part 3 and part 4, looking at the legislative process and looking at next steps. I think it's most of the industry following yesterday's announcement has taken the opportunity to absorb the information, to digest in their own manner, and so I didn't want to spend too much time looking at precisely the content of the speech, but I wanted to really focus on the legislative process, make a few fundamental points as to next steps, so that everybody is fully aware of what's likely to happen moving forward. So this slide gives you a general overview, a broad overview of the legislative process from where we are today. And so if you read from left to right, you'll see the King's speech as at yesterday, and then you'll see what happens next in terms of the lawmaking process. In a nutshell, we've had the King's speech, and so the next stage will be the publication of a draft bill. And just pausing here again, as before, some people thought yesterday's detail was somewhat limited. As I say, I think this was to be expected. And so when the consultation on rents and the bill are published, that's when everyone can get their fine-tooth comb out and start analysing in some detail. Also, there may be some leaseholders feeling somewhat buoyant after yesterday's speech. You'll see from the slide here that there's an awful long way to go. And this is the equivalent of my club, Leeds United, being 1-0 up after 20 minutes against Man United in the FA Cup final. Whilst it's great news that we're 1-0 up and it's positive progress for us that we're 1-0 up, we're only 20 minutes in. The first, the bill, this can take place at any time. And so just moving through this legislative process slide again, we'll receive a bill at any time from today until the end of the parliamentary session. I would say it's unlikely that they will leave it to the end of the session, but given the scope of the bill and the amount of content that's likely to be included, I expect that it's going to be detailed and lengthy. And so I don't expect it will be published immediately, but we may expect that in the coming weeks or months. Once the bill is published, containing all of the detail that we want to see, then it will start to pass through the legislative journey. And as I say, it's at this point we can get our fine-tooth combs out and start to give some careful thought as to how it may impact us and carry out our risk assessments, which I'll talk about in a moment. The legislative journey can be tracked on the Government Bills website and has multiple stages involved. More on what happens to the bill in a moment. Once it reaches the end of its journey, it will eventually receive royal assent, which is when the final version of the bill gets locked down And this usually happens quite quickly after the last stage of the legislative journey, and we saw that recently with the Levelling Up Bill. After it receives royal assent, it will then get a commencement date, and then the bill will become law. And now you may think all of that's quite easy, and once the bill's been published, everyone can relax and it will just rattle through this legislative process, and we'll all just see law relatively quickly in a similar sort of manner to what we see in the bill. And I'd say that's absolutely not the case. And so let's give some thought to what could go wrong. As you'll see from this slide, a lot can happen to a bill during the legislative journey. The Building Safety Act is a perfect example as to how a bill can change substantially during the passage of the bill through Parliament. For those of you that followed this at the time, you'll remember that the first version of the bill, under the then Secretary of State, Robert Jenrick, saw leaseholders picking up the bill for remediating, for the costs associated with remediating defects in buildings and buildings that were impacted. The Secretary Jenrick was then followed by the Secretary of State, Michael Gove, who immediately reversed this policy and deemed that developers and landlords was paid for defects. This was a huge U-turn in terms of policy making, and this forms now a major part of the Building Safety Act as we know it. The point I make here is that anything can happen, and so the points you'll see on the screen are some of the things that may impact on the bill or the content of the bill as it passes through Parliament. And the bill's journey can take months and months, which is in political time a very long time, and a lot can happen during this time. As I say, the point I make here is that no one has a crystal ball. Release of the draft bill should not make us all relax thinking we know what's what. The Building Safety Act is great proof and living proof that the content can change overnight and very rapidly. So with all of this in mind, where does this leave us? What should we do next? That leads me on nicely to my final part, which is part 4, looking at next steps. So in context, this slide looks at the impact that a change in law may have hypothetically. This may be on your interest if you're a leaseholder, or your interest or if you're a landlord. In valuation terms, it may be looking to the impact on your business if you're a supplier to the leasehold management or leasehold reform industry. My first point is back to housekeeping. We're just lawyers and I'm just a lawyer. Particularly with the first tranche of proposed reform on enfranchisement, a lot of this surrounds valuation. So my first point here is to assess with the valuers these things, hypothetically, in as much as you're able. My second point is to be honest and clear if you're professionals, as honest as I'm being today. We simply don't know what's going to happen. I simply don't know what to happen, and I'm quite happy to say that. I'm not happy that I don't know, but I'm happy to be honest with you in saying that I don't know what will happen. As such, for example, as lawyers, we can't advise on reform, and such to give clients any degree of clarity or certainty as to what will happen. All of what we say must be hypothetical, as purely from this point onwards, we are working within that regime. We simply don't know what the law will be as it ends up. So what's my suggestion? It is that all of this must be very carefully risk assessed. And my overarching suggestion is to do this in a manner which is calm and collected in as much as is possible. And so as to create a really careful and safe space to allow decision-making to happen. And please, my urge to the whole industry is do not make any knee-jerk decisions that you may regret. Keep an eye on existing deadlines. Here it's important to note that the law hasn't changed. I know that I'm repeating myself, but it's really important to note that the law hasn't changed. It remains the same. Any live claims need to be attended to very carefully within the existing regime. Also, in relation to potential claims, a good example is if a lease is just about to drop below 80 years. Under the current regime, that has a considerable impact on value. This has not changed. The law is exactly the same, and I appreciate I'm repeating myself. But that can, if you make decisions based upon the potential of change in law, you need to very carefully risk assess those things. And finally, another point here is to think carefully about how you can adapt to change. If this proposed reform does come to fruition, how can you change for the better? As such, if you're a managing agent, think about how you can adapt your business to suit a new reformed landscape, attending to things like greater transparency, greater processes, attending to sales inquiries that in a reformed manner, and streamlining those things in as much as you're able in a bid to maintain quality and all of the relevant content, and looking to adapt to proposed changes in insurance commissions, for example. You'll be pleased to hear that this is my final slide, and we can go on to Q&A after this final slide, but this looks at the long-term position. And most of this slide goes without saying, so but it's important to say anyway. The long-term position is perhaps even more uncertain because a lot of it surrounds transitional provisions, secondary legislation, and so as we've seen with building safety, for example, lots of that's still to come. Yet we still have we now have primary legislation to attend to. As I say, I won't go into all of these points in detail, but I want to pick out 2 points for you quickly. The first is it's worth noting that after royal assent has been granted, the new legislation can change, it can be challenged, by any party. There are various reasons as to why legislation might be challenged. This might include, for example, judicial review, where a party potentially alleges that there's a flaw in the content of the law, or that the law was made in a manner which was unlawful, or A1P1, and this is where a party alleges that their human rights have been affected. If a party brings legislation successfully, the relevant part of the new legislation, which is subject to the challenge, could be nullified. In this case, the law will go back to the old law as it was changed, or may need to be revisited. It's impossible to know at this stage if any new legislation may be challenged and by whom, but it's important to have in mind when you carry out your risk assessments that I'm suggesting. And then the second point that I want to mention is if these reforms come to fruition and are made law, they could potentially radically change the landscape for all concerned. It's hoped that this will be in a positive manner for really good positive change. And everybody currently involved in the sector should give very careful thought, very positive thought as to how change may impact them and how they can adapt for the better in the future. And on that very cheery note, that's all from me. Thank you so much for your time. I can't see any Q&A, but we've got now a healthy amount of time for Q&A. And before we move on to Q&A, if anybody's got any questions, I'd really like to thank you for your time and thank News on the Block and Vicky for arranging. Thank you.
No problem, Matt. I'll just give it a minute and see if any questions come in now. Normally it's a good sign because you've answered nearly everything that you could.
Should I stop sharing my screen for a minute, Vicky?
Yeah.
So an anonymous attendee has asked a question, which I'm quite happy to try and deal with. A lot of it's speculation, but I've been asked whether or not I think marriage value will be abolished and whether I think there will be additional changes beyond those stated in the briefing notes, such as fixing Section 33 and Section 60 costs. Just for those in the room that don't know what Section 33 or Section 60 costs are, those are the reasonable costs that are required to be. These are the reasonable costs, sorry, that are required to be paid by a leaseholder when currently exercising their lease extension or their enfranchisement rights of the landlord and any other relevant landlords. So dealing with the first point, I think that marriage value is likely to be abolished. Is my personal view. I think that's featured as part of a number of announcements prior to the King's speech, and that would be consistent with the overall messaging that's featured in recent times. Dealing with the second point, I think that a few of those eagle-eyed individuals reading the briefing note yesterday had spotted that in one of the examples as to the impacts that reform may have, there was reference to the leaseholder in that example only paying their own costs as well as the price payable. And so read into that what you will. Obviously, this really emphasizes the point that I made earlier in that we simply don't know what's going to happen, and we need to watch this space very carefully. Have a look at the next question. So I've been asked whether if there is an election or a snap or otherwise election and there's a change of government, what happens to legislation at whatever stage it's at? Well, it's my understanding that it will continue to be progressed subject to the policy decisions of the government at the time. I think that generally speaking, across all political parties, there is a will to move forward with some form of leasehold reform. But again, this emphasises the point that it may impact on the content, and so that's why it featured in that part of the presentation. So we've been asked whether or not there's any mention of what a reasonable administration fee for arranging insurance might be. I don't think there has been, not to my understanding. I haven't heard of any figures being discussed at all. I think that ultimately, I think that it would be important to give some very careful thought as to how if you're charging a fee associated with arranging insurance, how you justify that with reference to the work which is completed. And so if I draw a comparison with professional services, legal services, there are often well-trodden arguments surrounding seniority of the individual carrying out the work, whether or not you can introduce processes to streamline the work such that the cost is lower, but without impacting on the quality of that work. And so this really goes to the point of adapting to change, and I think in as much as is possible, particularly managing agents, I think should be looking to giving careful thought as to how they will adapt to carrying out these services and doing so in a way which doesn't impact on quality and maintains that quality, but keeps the cost as low as possible, so that it's not unreasonable. Fundamentally, it's not unreasonable, and also it's not challenged. Consequently, it's not challenged. Moving on. Yeah, so just following on LPE1 replies, I think some time ago there was reference to some fees, I think maybe £250, and there was no mention of that. The question raised by somebody in the audience is whether or not there's been any further announcement on that topic. I don't believe there has been, to my mind, but there may have been. But I think it's a case of continuing to see what happens there. Just to reiterate my earlier remarks, I think that it's important that we don't dilute quality. I think that when people are buying leasehold interests, they must do so in a truly informed manner with all of the information that's proportionate to make that decision. The next question is, for anyone currently in the midst of extending a lease, are you saying that although a lease extension will now be 990 years instead of on top of the residual? So the point is whether or not it's retrospective, the extent of the term, and the person asking the question is asking whether or not, if someone's extending the lease, their lease now, whether or not they get an additional term retrospectively. I guess it's the case of seeing what the law may look like in the future, but I don't think that that's what's being discussed at the moment. I think that I think what's being discussed right now is the possibility of changing the law for the future, such that leaseholders in the future making claims for lease extensions or new leases, as they're called, will get an additional 990 years instead of the existing regime, now an additional 90 years. One person's asked if we're in the process of negotiating a lease extension with possible tribunal proceedings being required in a month's time, are we in a position to pause this, and in brackets, happy to discuss this separately if easier. I think that this goes to the point that I made earlier. It's particularly important to stick to the existing law, to focus very carefully on the next step in the existing law, and to make sure that you're hitting those deadlines. The consequences of failing to meet a deadline on a new lease claim are that you're in accordance with your existing provisions, are that your claim will be what's called deemed withdrawn, and you'll have to start again, but you won't be able to start again for another year. There's a ban on starting for another year, and you'll have to pick up all of the legal costs associated with the existing transaction, yours and your landlord's. And so the consequences are quite significant, and those would need to be very carefully looked at against the backdrop of any potential reform. So I think that, in brief answer to your question, I think that focusing very carefully on next steps and not convincing yourself that there is an ability to pause is important. Hitting deadlines and then risk assessing your options as to whether or not you withdraw your existing claim and look to make a claim in the future under the new provisions. Thinking very carefully about the relevant professional advice that you need to obtain in order to make that decision, both legal, valuation, and any other. Is there any room for freeholders to be compensated for any loss in the value of their assets? So I think in brief answer to that question, I think what's the overarching point of the King's speech is that the leaseholders will pay less for exercising their statutory rights, what they pay at the moment, and what the law says at the moment in relation to what they pay is that is the compensation that they're paid for the claim that's being made. And so if you look at it in a simplistic manner, I think that the straightforward answer would be that any reform in law would be to compensate in accordance with whatever the law looks like in the future in a lower manner. As for any other compensation, I simply am unsure, and we'd obviously have to wait to see, but I'm unaware of any announcement on that topic. there's a question, was there any detail given on renters reform? I think that there was a line item with reference to renters reform. I unfortunately haven't had the time between the King's speech and reading rapidly those specific points with reference to leasehold property to wrap my head around all of the other announcements yesterday, but I will catch up on that. But it may be worthwhile digging out the briefing note and having a look for yourself as to whether or not the wider reform of tenancies and short leases is still on the agenda and what was said there. Someone's asked me whether or not Leeds United are going to achieve promotion this season. I'd like to think so, but the competition's tough, David. So we'll just have to wait and see. Very much like the content of the bill, we'll just have to wait and see. Really interesting question, Annie. Thank you. Do you think that the new legislation will require 990-year leases on all new leasehold flats, or will it still be possible for developers to sell flats on 99-year terms? I think it's a really interesting one. I don't know of any particular announcement on that. Obviously, we've got the abolition of ground rents on new leases going forward. But to my understanding, I'm unsure as to whether or not there's been an announcement on a minimum expectation of lease length. But there certainly wasn't yesterday in the briefing paper. Yeah, really interesting point that you make, Harry. I think that Harry's asked whether, if I may just paraphrase, Harry asked whether or not mandating share of freehold going forward on apartment schemes would protect consumers for on future developments, and also a comment as to Commonhold and the introduction of Commonhold. Personally, for what it's worth, Harry, I'm particularly sad, for want of a better phrase, that Commonhold didn't feature as a concept in this round. But that said, I do understand that that from my limited understanding of politics, that there's limited time, and getting through as much as possible in this round is important, and moving forward, I think that it's important to keep. I really truly believe that it's important to keep that on the agenda. Commonhold as concept. I hope that answers your question. Someone's just commented that the renters reform bill has been carried over to the current session of Parliament. So thank you for that. And I think I've answered, Vicky, that question regarding further compensation for freeholder.
Yeah, I think that's it. Yeah, you got through all of them. Wow, we had enough time to get through so many. Great. Thank you, Matt, for your time. Thank you to everyone who's joined us today. Hope you found that useful. We have another webinar coming up at the end of the month on service charge account preparation. So if anyone would like to join us for that, then you can register on the News on the Block website. Otherwise, the recording of this session will be available later today or tomorrow, and I can send that out via email. Otherwise, thank you for joining us. Thank you, Matt, and enjoy the rest of your day.
Thanks, everybody. Thank you, Vicky.
Thanks. Bye.
Bye-bye.